Okay, I will start. Hello, everyone. Welcome to join. This episode is about the new revision to the PRC Company Law. And today we have Mark from KWM London and Atticus and Jerry from KWM Shanghai to discuss what do foreign invested enterprises and the investors need to be on the lookout for with the new revision. If you have any questions, please put it in the chat or you can send it directly to me and we will have a Q&A session at the end. And a bit of a housekeeping. The presentation will be recorded and uploaded to the YouTube. You can search China Chit-Chat to play back and check out previous episodes. Okay, you can go ahead, Mark.
Okay, thanks. Okay, thanks. So I think we'll just do it quite informally. And I think we're concentrating on some of the main issues, which we think is particularly of relevance to the foreign invested enterprises. So the company law will affect all companies in China, but this one is just to talk a bit more about the foreign invested enterprises. So maybe we go to the next slide, Tom. Yep. Okay, so I think it was kind of interesting how different people approach different things. So Atticus had the idea to write an article about the impact on FIEs. So we did it, and my feeling was most of the changes are technical. It's a bit boring. And then I wrote an article, and I had a picture of a woman reading a book, How to Sleep Well, and then having a book about the new PRC company law, and that she would fall asleep even quicker if she reads the new company law. So I thought, it's not very exciting. It's stuff you have to know. And there's a few things which are a little bit interesting. But I kind of thought we should do something because an American client of ours sent us an article, and it's a big company. And the big boss of the company had received an article from a US law firm, which is only based in 2 small states in America. And, their article was not very long, but it didn't say what was actually happening, but it was saying these things are actually from the article. Failure to file will mean that you can't make any other filings. And then that companies that fail to meet the deadline will be publicly shamed by the relevant authorities, and delay is risky. So, the way I was looking at it is, okay, there's a new company law. You have to adapt over time. You have to do some housekeeping. No big deal. And of course, the American lawyers were saying the new PRC company law, you're all going to die. So I think from a marketing perspective, they're much better than we are. I think, it's really, the article was, it was interesting. So anyway, so maybe we move to the next slide, Tom. Okay, so maybe, I don't know, Atticus, do you want to just go through like the kind of basic, like a very high level overview of what changes you think are, kind of in the new PRC company law?
Yes, Mark. Hi, hello, everyone. So I think the big matter for, all the companies in China in respect of the, amendments of the PRC company law, this time the changes are substantial, and there are around 217 clauses were amended. So that's will have impact on all companies in China. Now we focus on the kind of the impact on the FIEs. But the interesting thing that maybe you want to know is the one is that the first one is the capital contribution. Maybe if you have a longer time that you're running China operations or FIEs, the history of the China corporation in respect of the capital contribution. Previously, there's a very tight time and amount that you have to be the registered capital, and then kind of losing the relaxation on the capital restriction. But now it's due to some issues or too high of the registered capital and kind of fraud cases, and there are a lot of debts or legal litigation. So now the company law kind of reverse the capital contribution arrangement mechanism. Now they have a 5-year limitation to make contribution. After the new company law, will take effect this July 1st this year, there will be a transition period. But now it's a draft of the Chinese authority says there will be 3 years of a transition period that you can, make those amendments. For example, if company registered or incorporated before this year, and they have 3 years to make the amendments on their AOAs to have the term of the capital contribution for 5 years. So there's a 3 + 5 year for the time that the term you can make the change on the capital contributions. And also I think that many of the directors or senior management on the multinational companies will care about the liability on the ultimate controller or the directors. For example, if the ultimate controller they're not hold any offices as a director, but if they execute the affairs of the FIEs, they may also need to have the obligation to perform as a director. And also, if they instruct the current director to do anything that harm the company or the shareholder, they will also have to take the several and joint and several liability as with the director. So that's also one of the new things in the new company law that hold the ultimate controller liable account. The other is the director can claim compensation if they unjustified fired. So previously there's China Supreme Court interpretation, and there's the company or the shareholder may make a reasonable compensation to the director if they are unjustified fired. But this time in the company law, this is given more room for the director to be compensated. And I think there are also other changes that maybe we can highlight them during this seminar. Mark?
Okay, thanks, Ed. So I think from an overview, there's lots and lots of other changes. Like I think now there's no limit on the number of directors. It used to be 13, but now it's unlimited. I don't think that will impact many companies. There's differences in the supervisory board. You can have an audit committee instead. If it's a big company, you need employee representation. So I think it will depend. So I think today we're not going to hit every possible thing that would hit every possible company, but just focus on the main ones. So maybe Tom, the next page, we'll see. So I think here, Atticus, talked a little bit about this already. So back in the old days, which was about, I don't know, maybe 5-10 years ago, you always had to bring in the capital contribution depending on the amount of money. So I think we're looking, the minimum kind of capital contribution used to be a total investment of about $200,000 US, and it was $140,000 US registered capital, and you'd have to bring it in within 6 months. If it was like 30 million, you'd have time to bring it in over a period of time. And this was difficult for people as well. So this would mean if you had a very big project, which is going in phases, you were perhaps nervous that, well, I don't know exactly what the second phase will cost, but if I don't get the approval now, what happens if I don't get an approval later and I'm stuck only in the first phase? So, so the fact that, the registered capital did have this deadline to come in, it was, a big issue. And I think the authorities made it easier. Just, you had to pay in the registered capital at some stage before the company, was extinguished. But it was no longer very tightly controlled. And they probably wanted to do this to increase foreign investment or increase, entrepreneurs doing things. But probably it wasn't a good idea because, as Atticus mentioned, it led to a lot of fraud cases. It led to a lot of people saying they were bigger than they actually were, and a lot of creditors were burned. So I think the issue for foreign invested enterprises is very often, and we saw one case of this a few years ago, where the local manager or the person who was promoting this new woofie of this US company, he really wanted to put in a registered capital of $30 million US. And, this was very surprising because it was really just the start of an R&D company, and the US company was like a relatively mature company, but it wasn't like a fully commercialized company. So it seemed strange. And, when we discussed it with the headquarters, they never ever thought they would invest $30 million US in China. But the local manager, he talking to the authorities, they were excited. They were treating him very nice because they thought this money would come in. And in the end, they agreed to a lower amount, but still more, I think, than they would have expected. So I think now in this case, they'd really be in trouble, because if they agreed to 30 million, they would have to actually pay it in within the 5 years. So I don't know, Jerry, do you have some comments about the liability for shareholders and how that might be changed by this requirement to pay in the registered capital?
Yeah, for sure. So the new PRC law provides some supplementary measures to facing with the situations that the registered capital is not fully paid on time. So, but back to the historical changes mentioned by Mark and ethics. So we do have experienced several stages of the administration and the registered capital of the companies. So under the current company law, so there is no time limit for the contribution, and the reason for that is that at the very beginning, the government wishes to encourage people to open the company, and I got the official statistics that the volume of the companies in China has been increased for 3 times during the recent 10 years, although 99% of companies, they are minor, small-sized companies. And speaking of the new PRC company law, so since we have now the 5 years time limit to pay up the registered capital, so the new PRC law proposed several measures. The first one is that as long as it's not the registered capital is not paid on time, so the board will have the right to issue the letter to such shareholder and to urge such shareholder to pay on time. If not, so these kind of unpaid shares can be transferred or even revoked by the company. So the shareholder will no longer have such shares. I think this is the first one. Second one, so Tom, can you move to the next slide? Yeah. So another one is also about if no one is willing to take over the unpaid shares, so then statutory speaking, other shareholders will need to take up all the shares, unpaid shares, by a pro rata basis. So this is something new under the PRC law, and this makes things interesting. Back to you, Mark.
Right. So I think that one is interesting, because I think the thing is, probably for a woofie, it doesn't really matter. But you imagine a scenario where you have a joint venture. The joint venture is in economic distress. The Chinese partner had agreed to bring in its contribution over a period of time. It hadn't made its contribution yet. And the old day, prior to this, I guess the only thing that would happen to somebody that hadn't fully paid up the registered capital was that they wouldn't be entitled to the full dividend. So if you own 50% of the registered capital, but you only paid in 20%, then you would only be entitled to 20% of the dividend. But if the company is in financial distress, there is no dividend. So there was no reason for, in that case, the joint venture partner to put the money in. So I think here, obviously, nobody knows exactly how all this will work in practice. It will be if you've got a joint venture that's in problems, it owes lots of people lots of money, and the board is in gridlock, which is often the case, and that means the board will not be able to issue these certificates. There is a risk that the shareholder who hasn't paid the money will be required to make up the difference. Because the company law is always talking about, the board will issue a notice. But I think anyone who's dealt with a joint venture that's really in a difficult situation, the board can't agree anything. So I don't know if Atticus has any comments on that issue, but I think this is a potential trap for somebody who's in a joint venture, which isn't going very well.
Yes, Mark, I think this one, forfeiture of the equity will will be a big battle for some of the joint ventures. For example, if the majority shareholder has not fully paid their contribution, they may not want to, to lose their equity, and they will stop in any event, prevent the board to issue such of a notice. But the minority shareholders may want to, the board to act according to the law or based on the article of association. So in practice, we can imagine that there will a lot of fights between the shareholders if one of them or some of the shareholders or the majority shareholder have not paid this fully paid contribution, because forfeiture of the equity will have a lot of impact on the power of the shareholders. For example, if the unpaid equity reach a certain amount, then the majority shareholder may lose the status of the majority shareholder, and they cannot able to, for example, if they appointed 5 or 3 directors in the board, they are no longer able to do that again, or based on the status they have to forfeiture of the equity. Another thing that is there's a fighting between the shareholders. But for example, if the shareholder, one of shareholders maybe face the forfeiture of the equity, but there's no solution, the existing shareholders, based on the new company law, we have to make contribution based on their pro rata of the equity. So this may also be an issue for those other existing shareholders, how they deal with that. For example, if they do not want to buy any solution for them, I think this will be a battlefield in some joint ventures if they are the shareholders not in line with the operation or the path or direction of the company.
Yeah. So I think I'm starting to think maybe the company law is interesting now. So because the example again is registered capital reduction was always impossible. 10-15 years ago, it was like seeing the Loch Ness monster. It was so difficult to reduce the registered capital. It's become easier, and now the new company law makes it easier again. But in almost all articles of association that I've ever seen of a joint venture, reduction of the registered capital requires a unanimous board resolution. So, I think the problem is, again, just to highlight to people, if the company is in this situation and it's got economic problems, it's very much like joint venture contracts where they have a beautiful contractual thing. People will do this, the board will do this, they'll hire a joint valuation expert, and they will all behave very reasonably in accordance with the contract until there's a problem, and then nobody follows the contract. So I think here you can really see that people will be directors in boards. The board is not going to issue these resolutions. You don't reduce the registered capital. You don't agree to forfeiture. What happens if you're stuck like that, and then a creditor makes a claim against you because you have to pay the company's contribution, as it says here? So I think it's complicated, and we'll talk about it in one of the later slides. Another complication is it's always been a problem in joint ventures in China, Sino-foreign joint ventures, that by its nature, the joint venture should be a separate company, but who do the directors of the company represent? Do they represent the company, or they represent the joint venture partners' interests? And so this also, again, is putting more liability on directors, to have fiduciary obligations, but who are they owed to makes it complicated. So I don't know, Jerry, you have any last comments before we move from this point, or?
Yeah, I think it's all for this page.
Okay, right. Okay, Tom. Okay, well, Jerry, you've been quiet, so maybe you can talk a little bit about the legal rep, the board of directors, the supervisors, and the general manager.
Yeah, for sure. So the legal there are also some slight changes on the legal rep. So the legal rep used to be must be the general manager or the executive director or the chairman of the board. So now it's getting a little bit wider scope so that any director or general manager who represents the company to do the corporate affairs can be the legal rep. So the common understanding is that the legal rep used to be implied as a leader of the company, but now it's more of like a representative. So it's like doing something on behalf of the company. So I think this is a slight change, but it's still to be further observed if any company is willing that to have some directors or general managers who is not leading the company to take the role of a legal rep. So this have two sides. The benefits would be the legal rep will somehow ultimately this person may take some individual liabilities as the legal rep. This is the tricky one under the Chinese law. And but on the other hand, the legal rep normally presents more power, and like he has the power to sign on behalf of the company. So this is the very complex factors for companies to determine on case by case basis.
Yeah.
So board of directors.
I didn't really understand why they did this, to tell you the truth, because I think, it made sense to me before because the chairman, they're normally non-executive, they're normally not that involved, but it was kind of like an ultimate person, and, normally the legal rep is not liable for the company. It's normally only something very, very bad, very non-compliant has happened. And the general manager equally, he's really in charge of operations. So you could understand why those guys have to be. But it's so hard to understand how it will work if you have a chairman, a general manager, and two directors, and then one of the directors is the legal rep. How does he fit in the pecking order? Because how does that work? It's a change that's very hard for me to actually understand what was the advantage of doing it.
Yeah, unless one exception is that if the legal rep, if the chairman of the board is normally not resident in China, but as a legal rep, he has to sign up a lot of like documents. So that might be a minor reason for people to choose, or for companies to choose a non-chairman to take the role as a legal rep.
Mark, maybe I jump in here for the legal rep. I think that the company law, the revision on this, who can be the legal representative of the company. This actually, I think, is kind of reflecting the new civil code of PRC. In the PRC previously, I think in the old, maybe many years ago, there's a concept that someone, for example, the legal representative is a kind of a statutory role. And for example, the general manager or the general manager who in charge of the plant, they know everything of the company, and the chairman know everything of the company. There's a kind of a statutory role or officer, for the legal rep. But the civil law, PRC civil law, they changed the idea of this, the legal rep to anyone to acting for the company with the authorization. And I think that's maybe to be consistent with the civil code. The other one, I think, on the new company law, there's a governance kind of governance change, governing change. I think the changes, the substantial changes from the make the board play more role, have more power in operation of the company rather than the shareholders. So this make the director have more power to act for the company. I think this may be some of the reasons for the changes.
Okay, great, thanks. Okay, you didn't put that in our article, Atticus. All these good ideas. Okay, so Jerry, what about the board? I guess Atticus has talked a little bit about the board, but maybe just briefly, what's the changes for the board?
Yeah, I think the most significant change for the board is that the board is now be allowed to set up an audit committee to replace the role of supervisors or the board of supervisors. So this is a huge change So for the long time, speaking of the establishment of the PRC law in 1990s or even earlier, so supervisor is for all the time a very important role for corporate governance under the Chinese law, because we follow the style of like German company law, speaking that the supervisor should be like balance the power, and they are like making their rules against like the shareholders, like the board, to supervise everyone is doing the right thing. But now the new company laws indicates that it is not allowed that the board set up the audit committee, and in this case, company can choose. The first one is to still keep the role of supervisor, but with the different duties and responsibilities specified in the articles of association. And another choice will be they simply company set up the audit committee without keeping the supervisor or the board of supervisors. So I think this is the huge change. A supervisor is actually, yeah.
Maybe Atticus, with his knowledge of the general principles of civil procedure. So I think, yeah, the supervisors, it might look good on paper, but with the FIEs, especially if it was a woofie, I don't think the supervisors ever did much at all, to be fair. Yeah, to be fair. And I think the role of the supervisor really was if the board and the management would conspire against the interests of the shareholder, the supervisor would have legal standing to bring action. Because otherwise, if the board and the management control the company, how can the shareholders, especially if you're a woofie, take legal action to a Chinese court? Very difficult. So that was, I think, the core idea of the supervisor, at least for FIEs, the key impact. So the question is, if we lose that, if they have an audit committee, which the board sets up, if the board and the management conspire against the shareholder, and it's an overseas shareholder, what do they do? How do they take action?
Yeah, Mark, I think this is really, kind of a questionable how this, the kind of, audit committee, how they act, because, the audit committee, they're all directors. So they cannot, kind of, supervise themselves. I think that's one of the confusion things that, if this mechanism indeed implements. And also, I think, the role, as you mentioned, that if they don't have a board of supervisors, the law indeed give the audit committee the power to sue the management or the shareholders. But indeed, if they are the directors and how they sue themselves, I think that's something really need to be considered when this in implementation.
So I think the FIEs should keep the supervisor, even if it's just one person, because I think it's unless somebody has a better idea, but I think that's something, because we have to keep on remembering this company law is not written for the FIEs, which are probably like 1% of the companies. It's really for the mainstream Chinese companies. So I think it's different. They're thinking from a different perspective. The shareholders are on the ground in China. They can take action more easily. So I would think maybe FIEs should think about keeping in a supervisor. Okay. So Jerry, you want to round it off with the general manager? Any comments on that issue?
Yeah, general manager is compared to like the supervisor, directors change. So these are basically almost the same as the old PRC law.
Somebody's got a question. I don't know if Tom can read it, because I can only see the question. I can't read it.
Yeah.
Tom, you're on mute.
Oh, sorry. So the question is, if the woofie have more than 300 employees, have only one shareholder, and choose to have an executive director instead of board of directors, how to handle the employee representation? Is it still mandatory? And also, is there a grace period and further clarifications to be expected in implementation guidelines?
Yeah, I think for this question, at least, based on the new company law, if you have employees more than 300, that you must have a employee director, unless there's an exception that you have already employee supervisor in the board of supervisors or as a supervisor. But there's different kind of interpretation on the new company law. So if we read the articles of the new company law in this way, I mean that you don't need to have an employee director in the board of directors, or if you already have a supervisor, employee supervisor in the board of supervisors or as a supervisor. If this is the correct interpretation of the new company law, that you can avoid that, you have some employee must have an employee acting as a employee director. So that this is the one way. The other is, if you have to have an employee director, maybe executive director is no longer kind of functional. Yeah, possible that you may need to have a board of directors to control all this operation.
Yeah. So I think if it's an FI, if it's a WFIE, because I think that's what I said, it was one shareholder. If it was a WFIE, so probably your better solution would be to put one of the employee representatives on the supervisory board. I would think it's probably, if you can do it that way, would be the better way. And I think if you had 300 employees, you probably would have experience already with having a trade union. You should have had a trade union. And I think you would realize that the employees are not like, those employee representatives are not normally like activists. They're normally people that help perhaps adjust things, help on compliance, but they're not going to be like demanding pay increases. So I guess there's an issue of management. Of course, things can change always, but maybe that's the solution, is better to park that person in the supervisory board. Okay, well, thanks for the question. And maybe next slide, Tom. Okay, so maybe I'll have a first shot at this. So I think Jerry mentioned at the start, with many FIEs, it's often controlled by people who don't have a formal role. It's often the CEO of the foreign investor, especially if it's like a medium-sized, company from the US or Europe. And so, one of the kind of questions we've had over the years is, we have a case at the moment, perhaps we can think of, there's always the chance that somebody has left the company, the overseas person, and has acted not in the interest of the WFIE, nor even in the interest of his own company. So so that would be like a rogue person involved in fraud or embezzlement, etc. But if that person, if most of the bad behavior occurred in China, but the person doesn't appear anywhere on the Chinese documentation, it can be struggling. It can be a struggle to tie them into the fiduciary duties. So I think that's one issue, is when we have a bad player. But then the other issue we have, I think, is a very common problem we've had for many years already, and it was most acute. We have a few joint ventures which were listed companies, not many, but when it was a listed company, it made it very difficult because in all your joint ventures, one side will appoint its directors, the other side will appoint their directors, and I think it's very clear that those directors, they follow the orders of their investor. They don't always think of what's the best thing for the company. And so I think the question is, how we deal with this. And I think it's very positive that the actual controller will also face liabilities, because, if you're making all the decisions, but you face no liability, that's not a very good legal basis. I think the other aspect of this is, we always talk about, piercing the corporate veil, and we always think of it like horizontally. It's like somebody, we always think of it as being vertical. And, it's always like, oh, this company set up a company, and, the company on top has all the assets, and the company below it's doing all the bad mischief. But very often, we see in China, you can have a problem against another company, And the Chinese entrepreneur has many companies, and it's very unclear which company is which. And you're not always wanting to go up. It's sometimes horizontal. So, even if he's sitting and controlling it from up top, sometimes they have, I met one person once, he told me, this company, which has almost exactly the same name, this company does the contracts, this company holds the assets, and this company gets the money. And so they're all on the same level. So sometimes these companies are very, very opaque, and I think it's a positive thing. Of course, it's always difficult, but I think it's a very positive step that people who are the actual controllers will face consequences. And also perhaps it's something to be aware of. If you're really instructing the management of your woofie or the joint venture, you have to think a little bit about how you will protect yourself and how you also, listen to, what the interests of the company is. So I don't know, Atticus or Jerry, do you have comments on this?
Yes, I think, for the PRC, the view of the actual controller, I think now on the PRC new company law, I think last time we do a training to a Chinese group company, they have many subsidiaries, and they have the key management for all those companies. I think that's not uncommon in China. They have this key senior management for a couple of subsidiaries. I think the key issue now is to avoid kind of piercing the view of the as Mark mentioned, to subsidiaries. I think that's you make sure the company subsidiaries financially independent. Even you using, for example, you appoint those directors or senior management for a couple of subsidiaries, but you need to make sure financially they are independent, and you don't using this company to sign this contract for another subsidiary, and you miss up all those funds of the subsidiary, to make sure that the company are independently operated. I think that's maybe the key issue to address this legal requirements.
Jerry, any points from you?
Yeah, I think the pending issue will be in practice for future litigation. One is wishing to claim for PRC in the view of the actual controller, especially for these global senior managers coming to China doing the business. I think this is the reason I said this is pending, because it is to be further tested by the PRC court to what extent still such claim will be supported. So, for example, whether it needs any formality issues, whether does it matter how such global senior managers coming to China claim themselves, and how do they introduce their relationship with the woofie, etc., etc. All these factors will be taken into consideration by the PRC court. So I think this is a point that worthy to further monitor from the PRC law practice.
Okay, great. Okay, Tom, maybe the next slide, please. Yeah, so I think, so I guess we were talking about, directors, and I think we've mentioned a few times about how, firstly, it's a bit of a strange idea for me, for a foreign invested enterprise, for the director to be paid remuneration. So I think in every joint venture contract that I do always, we actually even specifically say that they don't get any remuneration. They can get their expenses reimbursed by the company. And I think, just by the nature of it, also, if it's in a woofie, we've always thought it's probably better not to have the management in the woofie's board. Let's say you have, 3 directors in a board of a wholly foreign owned enterprise. It's normally just cleaner if the management's separate, because, if you have them in the board, it can, perhaps mix things which should stay apart. So, in the typical wholly foreign owned enterprise, the 3 people in it will be normally head office people who are involved in the China business. So I think, the issue there would be they get their remuneration as part of their overall package. So I think that's one issue. The other issue, which is also very, strange for me from my perspective, is that in China, it's very hard to terminate employees. You have to have lots of reasons. It's more like, perhaps France than it is like America. Some people think, oh, it must be easy to fire people. But in China, there's a lot of protection for employees. But I had always understood that directors just get revoked with a shareholder letter, no discussions. Maybe with the legal rep, it's a bit different because, you need to sometimes get their agreement in certain authorities. They want to see the agreement of the legal rep. But, people change directors all the time. And so the fact that you'd have to justify it is a big change for me. So I found that strange. And, the idea of compensation. So I think, just to sum it up before I let, maybe Atticus and Jerry have some points on this, it's a very big change for foreign invested enterprises because firstly, the people were not separately compensated. Secondly, I never thought anybody thought they have to justify removing a director. And then thirdly, how will we deal with compensation? And very often the most difficult people to terminate are general managers who are also in the board. And, this will be another thing. And maybe the headquarters won't be aware of it. And I could see somebody coming up with an agreement, a package of compensation, and then everything's signed and he's been paid. And then the person says, oh, I also need compensation for, not being a director anymore. So I don't know if Atticus or Jerry, you have, points. Do you think it's interesting? Do you think it makes sense for foreign invested enterprises? What do you think?
Yeah, I think Mark, you mentioned a couple of points that I think there's a kind of challenging to the multinational companies to to implement these clauses, these requirements. Many companies, multinational companies, they appoint directors for their China FIEs, for multiple subsidiaries, and they want to change this, due to their role changing or other any reasons because of the operation. So one of the solution, the companies in China are thinking about this is when they appoint a director, they kind of to kind of think about to sign a contract. It's not a labor contract or employee contract, but it's a kind of contract with the director. So to make sure that to not trigger these clauses. For example, in the contract that you said maybe that you have we give the opportunity to appoint as a director of China for a subsidiary, and there's no compensation for you to. For example, we can appoint or remove you for the following reasons. We can make the reasons broad. And normal, including all those due to operational or company commercial reasons. I think that's at least one of the things that the companies may need to think about to be prepared before this new company law implements. Otherwise, I think there will be a lot of, as Mark mentioned, this may also be complicated with the labor law issue, and you dismiss the director, and also there's a lot of, maybe there will be a lot of disputes, and unhappy director, they will bring lawsuits action against the company. So I think, at least as said, one of the documents that you be prepared in advance to kind of solve this problem in advance.
But I don't actually know the answer. But in China, if there's a director and he's got a contract, that must have happened also in history. So it never happened with the directors I've ever seen. But if he wants to sue or she wants to sue somebody, do they go to the labor arbitration tribunal? Or do they have to go to the normal court?
I think this is not on the PRC employment law, because appointed director is not establish the employment relationship.
Okay. So I think that's probably important, just to specify that in that agreement. You'd say, look, this is not an employment relationship, because once you go to the employee arbitration, it's very pro-employee. You have all these other things. And then because it's not very clear, it just says that you can't, remove them without justification. But if they then will say, well, justification is the same protections an employee gets in China, then it's, difficult. Jerry, you look concerned. Are you a director? Are you? Or?
No, I think so. So apart from the document design, so I think the document design can be put into two stages. One is the times that the director is to be appointed. So maybe this is something beforehand, so clarify all the rules. So we are not so you will accept all the like arrangements, etc., etc. And another point will be when the company is looking forward to like is looking to remove such directors from his office for position. I think this, if ideally possible, so we will have them to sign another like resignation form or other like acknowledge form saying, okay, this is a justifiable adjustment of their position. So if possible, so I think documentation is as a must set for companies to, especially FIE, to consider. So on the other point is like if it goes to the litigation, and there's some factors also need to be considered. For example, some directors simply do not, based in China, do not participate in the daily operation of the WFIE. So this kind of the compensation for this kind of like directors, I think will be it will be arguable. So to say how much would the compensation be, and otherwise, if the director is doing his business offices in China and devote into the daily operations of the WFIE, so I think this will be a different story.
Yeah. Okay. Good. Any more slides, Tom? Or was that the last one? I can't remember if we had any.
Let me check. Yes, we have the next slides, and also we have a question from the audience. Do you want me to read the question first, or you do the slides?
Yeah.
Okay.
Yeah.
So there's three questions from Dr. Rolf. I'll read out the first one. The first question is: do you expect an increase of insolvencies of companies due to failing capital contributions by the shareholder?
I don't think there'll be. I mean, I don't think. If anything, this will force people to put in capital contributions. So I don't think it will lead to insolvencies. This changes could only lead to more people actually putting in the capital. It'll probably lead to a lot of people seeking to reduce the registered capital. So I think if you're a healthy company and you have no problems, you should reduce your registered capital as soon as possible. The difficulty will be once you're in debt and you have creditors. So I don't think that'll be the issue. I think, maybe economic reasons, it seems at the moment, the economy is less good than it was, previously, but I don't think this change will lead to any higher levels of insolvency.
Okay, and the second question is, what is the monetary impact of Article 18 of the new company law for the companies? Do companies have to pay or reimburse the costs of party activities organizations in a company?
Yeah, maybe I answer this question as try to answer this question. And this question is very interesting. Article 18 is says that in a company need to, according to the article of the Communist Party, need to set up the organization or organ of the CPC and implement all those activities, and the company should provide necessary condition for the activities of the party. So I think based on my understanding of the new company law, they have not specifically imposed a liability if the company has not do this. As I read the article, the company law says the new company law says that the company needs to provide necessary condition for the party's activities. So I think necessary conditions normally, for example, that if you have 3 members, that you need to have a committee, party committee, and to give them the time and also space for them to perform the activities of the party. Naturally, there may involve some of the financial support or aid for all those activities, but I don't think this will be heavy cost for the company to do that.
Okay, Thanks, Atticus. And the third question is, the liability of the actual controller for derivatives is similar to the German rule of the factual group of companies. Are there liability rules for companies that have contractual obligations to a parent company under the new company law?
Jerry, you haven't answered yet, unless Atticus is burning to answer.
Yeah, I think I think have the contractual obligations to a parent company will not cause the absolute liabilities. So the new company law is wishing to improve the environment, but it's not changing the very substantial business. So to my point is so contracting to the parent company will not cause direct liabilities, but depending to like Atticus, if you have any comments on that.
Yeah, I think, from my understanding of the new law, there's no specific rules on this, the kind of contractual obligations for the company to the parent to the parent company.
Yeah, I think maybe it's related to the ultimate controller and the piercing of the corporate veil. So I guess that will make it easier to establish liability. But I don't think, from when I remember reading it, it didn't have specific rules on how liability is measured or things like that. But at least it would open up the possibility to attempt to pierce the corporate veil, which I think is probably what the question was getting at.
Yeah, I think the company law is more focused on the PRC company entities. If you reach out to the parent company, I think that's kind of beyond the jurisdiction of the law.
I'm talking about Chinese companies, so I think it's going to be difficult for them to extend it to Germany or to America. But I guess the issue is it's a law, and so the enforcement or difficulties is a different thing. So in summary, I guess, look, I think it will have an impact. I think, as you can tell, there's a lot of things which are changing. Maybe you're in a danger camp if you have a very large uncontributed registered capital. You might be in trouble if your partner hasn't contributed its capital and the joint venture is not in a very good situation. There are a lot of things we didn't discuss, like equity transfer rules. Again, I think they're very technical, but you might need to update your relevant documentation, including like your joint venture contracts. Also, it's worth remembering that the 5-year transition for the foreign investment law expires at the end of this year. So you probably have to make sure that you are compliant with both. So you might need to actually update the controllers, check the senior management, and also see what kind of contracts you have to have in place to make things clear with ultimate controllers, directors, and all these kind of things. Any other final points, Jerry or Atticus?
Yeah, no for me, Mark.
Yeah, I think Mark made a good summary of this, or those changes. But I think this time this new company law has a lot of changes on the company, on the a lot of new requirements for the operation of the Chinese companies. So I think for the multinational companies, especially for their FIEs in China, you need to consider those must-have clauses. For example, those capital contribution or governance structure, all those you must mandatory requirement you need to follow. And you also need to kind of consider what's those options that you have to make it easier for you to operate in China. I think there are a lot of changes and requirements on new company law I need to pay attention to.
Okay, great. Is that the last slide, Tom, or is that it? Or well, it looks like it is.
Yep, this is the last slide.
Okay, we should really have an end slide. I forgot to do that. Okay, so Tom, I guess we'll upload the slide to YouTube or whatever. So thanks everybody for joining today. And if there's any questions, just feel free to reach out. We're also happy to have a chat with people, just to see whether you need help, or if you just got any little questions. We don't have to start opening a file or anything, just to have an informal chat about how it might impact you. Okay. So, well, thanks, Atticus. Thanks, Jerry, and thanks, Tom.
Thanks,
Thanks,
everyone.
everyone.
Thanks. Bye bye.
Bye-bye.
Bye.